Welcome, I'm Jim Cunningham. Today we're going to talk about protecting a child's inheritance from a future ex-son-in-law or future ex-daughter-in-law. So that is somebody that your child will divorce, but isn't necessarily divorcing just yet. So disclaimer, I'm a lawyer. I'm talking. This is not legal advice, okay? Don't go out and do a bunch of stuff based on this. This is information only. Subscribe to our YouTube channel. Very important to stay on top of the latest developments. If you're watching this live, of course, you can go to our YouTube channel and subscribe. I'm an attorney. I've been in practice 25 years, over 25 years, offices in the Sacramento, San Francisco Bay, and Southern California office. I'm a certified specialist in estate planning, trust, and probate law. I used to do a lot of trust and estate litigation. I've seen a lot of these issues come up with people. I'm also a real estate broker as well, and securities and insurance license. So I thought I would start out with a funny quote. I love Voltaire. Behind every successful man stands a surprised mother-in-law. So if you're the mother-in-law looking at your son-in-law going, I don't know about that guy, that may be you. But what we're going to talk about today is the really big issue and the reason, frankly, why you're watching this, which is how do we reconcile that all property acquired during marriage is presumed to be community or marital property? So in California, this is the rule. Property acquired while two people are married is presumed to be community property, except property acquired by a gift or inheritance. So what we're talking about specifically here, we are not talking about your kids who might get a divorce and how your kids, your soon to be divorcing child, can protect his or her own assets. What we're talking about in the context here is this is your estate. This is what you've taken a lifetime to accumulate. And when that passes to a son or a daughter, that when that property goes to them, that it is protected, right? It is designed to be protected from a lot of bad things that can happen. And I will tell you, divorce, I think, is the single biggest threat to an inheritance after taxes for some people. So what's the problem here? If it's community property, except if it's acquired by gift or inheritance, well, that should just decide it. But we don't live in a static universe, okay? So let's say that, mom passes away, she leaves property to the son, and then years go by. Could that property become community property? Well, it's actually very easy to transmute. Transmute is a legal term, which means change. It's very easy to change property from separate property to community property. When you compare that with transmuting or changing community property to separate property, that actually requires the involvement of lawyers, okay? So that's not an easy thing. Typically it involves lawyers. That's not an easy thing to go from community to separate, but to go from separate to community, much, much easier. So I'm going to pose a question here. Anna inherits $1 million from her parents, goes into her bank account, right? She deposits this inheritance into her joint account with her spouse, Bob. Anna makes a few mortgage payments from the joint account, and Bob, of course, testifies in their divorce proceeding that Anna told Bob that the inheritance was community property. Is this an effective transmutation of property from separate to community? Sad to say, the answer is yes. It is now going to be subject to a community 50-50 division of community property. Now, it's very important to understand that just because Anna put the property into a joint account does not mean that the property automatically becomes community property, okay? Just because it goes into a joint account. But when you couple that with Anna using those payments to pay a community debt, which in this case is the mortgage on the house, plus Bob's testimony that Anna said that she intended this to be community property, that's how we get this result. So how do we solve this problem? And I will tell you guys, I think you can see as we start unpacking this, you go, wow, this could be a really big problem. Half of marriages end in divorce, half. The other half end in death, okay? So 60% of people, their marriage ends in divorce. I think there are more people getting married and divorced, obviously, than there are getting married and passing away. So we use a few vehicles here. We use three kind of main vehicles, but they all kind of have the same, essentially the similar functionality. So Anna's parents can create what we call an inheritance protection trust. Now, that's what we call it internally in our firm because we are focusing on the benefit. This is known legally. So if this is a lawyer watching, this would be a continuing trust, okay? But a continuing trust is kind of plain vanilla. It really doesn't tell us what this trust is for. This is to protect Anna's inheritance, right? So the parents can set this up in the parents' own living trust. This is not something that Anna can set up on her own after her parents die. So after Anna inherits, Anna can be the trustee, okay? And the assets in the trust are available for Anna's needs, but they are not owned by Anna. So Anna is the beneficial owner, and here she also happens to be the legal owner. Sometimes for lawyers who are watching this, you would say, what about the doctrine of merger? We've written some terms into the trust that that keep the property from merging all into Anna's name. But the idea here is that Anna is in control while she's a trustee of the trust, while everything's fine. And there's another variant on this. So this is the inheritance protection trust. This is where Anna is in control. But you might also say, you know, Anna really isn't that good with money. And I'm afraid if she's in control, her spouse is just going to strong arm her into taking all the money out anyway. So we want to name somebody else other than Anna on this trust. Well, this is what we call internally a dole it out trust, because the money is doled out to Anna. So after Anna inherits, mom and dad die. After Anna inherits, Anna is not the trustee because, and I left that blank because you can insert whatever, because she's not good with money, because she is, well, that's pretty much it. Not good with money. You know, I don't like the way she spends money. I don't think she's good with money. That's pretty much why people do a dole it out trust. Sometimes it's youth. Sometimes it's just not young enough. Maybe, you know, if you're 16, you can't be trustee because you're not 18. Okay. So the assets of the trust are available for Anna's needs, but they are not owned by Anna and they are not controlled by Anna. So that's really important. So she gets the goods. She's the beneficiary, bene, meaning good in Latin. She gets the goods, the beneficiary, but she's not the trustee and she's not in control. Then there's another one, a special needs trust. If Anna is a recipient of supplemental security income, that is SSI, we really encourage our clients to take a close look at using a special needs trust if they're going to leave anything to Anna. And this is for a disabled individual, not SSI. Not SSDI, Social Security Disability Income. Many times we don't use a special needs trust if a recipient is receiving Social Security Disability Income, SSDI. But with SSI, in most jurisdictions, you're going to want to set up a special needs trust. So the assets of the trust are available to supplement Anna's needs other than food, clothing, or shelter, and they are not owned or controlled by Anna. So those are the three kind of variants of these continuing trusts. And I'm going to give an example, a concrete example to bring this home. Something else to be mindful of, we have a video on our YouTube page about trust protectors, and a trust protector, fundamentally a trust protector is an individual who has power over the trust, but is not the trustee. So the trust protector is there to remove Anna as trustee, right, on the inheritance protection trust if Anna gets into trouble, because there's an axiom: whatever you can get to, your creditors can get to. Whatever you can get to, your creditors can get to. And that's just kind of a general concept. There are some few exceptions on that, but that's just a general asset protection concept. And so a trust protector is there to remove Anna. So if Anna's getting a divorce, it might make sense to remove Anna to, you know, make sure that this creditor protection, this divorce protection is enhanced and ultimately hopefully works. But and the trust protector removes Anna and appoints somebody else as trustee other than Anna, so that she has no access to that money. And therefore, if she has no access to the money, you know, that money's just not going to come out of the trust to pay her obligations. Now, that being said, there is an exception with spousal support and child support. There is a limited amount that can be forced out of the trust. And by the way, this is not a structure to evade the child or spousal support system. I'm an officer of the court. I cannot counsel someone on evading a court order. That's an ethical breach. It's not what I'm saying here. What I'm saying is primarily the 50-50 division of community property at death. That's what I'm talking about, or at divorce rather. So we believe that a trust protector is necessary for an inheritance protection trust, as well as a dole it out in a special needs trust, because certainly on the inheritance protection trust, you really do need this trust protector function in order to maximize Anna's protection. But it's also a really good idea, because one thing a trust protector can do, as I mentioned, they can remove a trustee. They can appoint a trustee. Well, some of these trusts go on for decades, right? Many decades. And the people you name as trustee simply may not be around. And a trust protector is there so that you don't have to go to court. So a trust protector is kind of like a get out of court free card, right? From Monopoly, the get out of jail free card. So trust protector is a get out of court free card. You don't have to go through the court system to replace a trustee or to add a trustee. Normally you would. Okay. Normally, if you don't have a trust protector, you would have to go to court. So what I'm seeing patterns. I've been in practice 25 years. This is not an outright distribution. Okay. What we're talking about is, many times trusts are written and it will say, I leave everything to my 3 children and in thirds. And if they're under 25, their respective third will be held in trust until they reach age 25, at which point the trustee shall distribute the estate, that 1/3, to the child because that child's reached 25. And what that is that's forcing the trustee. By the way, a trustee must follow the terms of the trust. The trustee does not have discretion to do something different. They have to follow the terms of the trust. The trustee does. And so when that beneficiary reaches 25, well, that beneficiary might be in the middle of a divorce, right? They might be getting a divorce a couple of years later. They might have some creditor issues. It could be a whole variety of things. They may not even be alive, right? So who knows what can happen. But I would say that on a high level, what I'm seeing in the estate planning area is really in the last 10 years, 15 years, there's been a movement away from outright distributions, primarily for 2 reasons. Number one, we're realizing that, it's worth protecting. But secondly, I think inheritances are getting a lot bigger, right? I think there's been a lot of wealth created in the last 10 years, certainly the last 20 years. And so these inheritances, what used to be 50,000 or 100,000, might be 500,000, $1 million, 10 million, 20 million, right? They could be very large numbers, and it's definitely worth protecting. And remember, you do not have creditor protection, divorce protection with an outright distribution. Only married people can own community property. So if you're single, you can't have community property. Only married people can own community property. Well, if the trust owns the inheritance, okay, it can't become community property. Okay, that's part of the logic that goes with this type of analysis. So let's look at Anna and Bob's divorce. So Anna, this is an example here. Anna and Bob are married. Now Anna's the daughter of her parents. Okay, so and Bob has been waiting for Anna's parents to die for a long time. Okay, now this is not uncommon where we meet with children when they come in with their spouse and they're like, finally, those Anna's parents finally died. Thank goodness, whatever it is. But Bob's been waiting for Anna's parents to die for a long time, and they finally do. Now, following deposit of the inheritance into Anna's joint account with Bob, what does Bob do? He files for divorce. So what are Bob's rights? Okay. Anna and Bob's divorce. Anna now has more assets, right? So even if this is her separate property, it's an available asset to her and can be used to enhance Bob's spousal support, potentially Bob's child support, where Anna might have to pay child support to Bob. So the existence of this asset in Anna's name, the separate property asset, even if it's not subject to a 50-50 division, increases Anna's assets and makes it more likely that she will have to pay a higher level of spousal or child support. And also, Bob may be entitled to a division of community property, and that's if Bob can prove Anna transmuted or changed Anna's separate property to Bob's community property. Okay, so she can, if Bob can prove that Anna transmuted that property, then Bob has a really good shot at winning. So how do we solve this problem? So Anna's parents must have set this up. Okay, so let's just assume that we're not doling it out to Anna, that she's not special needs. She's not an individual with special needs. So Anna's parents, not Anna, it does not happen after Anna gets the inheritance. It's much more difficult to do this type of planning. But Anna's parents create this inheritance protection trust as part of their revocable living trust. And on the death of the parents, that's when this inheritance protection trust springs into action. So you can kind of look at it as like there are the seeds that are planted in mom and dad's estate plan, and that when mom and dad pass away, these seeds grow into this inheritance protection trust. Anna can be the trustee of the inheritance protection trust. And the assets are available for Anna to access, but they're not owned by Anna. So when Anna then is served with divorce papers. She reaches out to Cunningham Legal. We wrote up this trust for Anna's parents. The lawyers at Cunningham Legal know how to contact the trust protector. And we reach out to the trust protector, and the trust protector is there to protect Anna's inheritance, to protect the trust, right? To protect Anna. And the trust protector removes Anna as trustee and appoints another person as trustee. So that's kind of the basic structure. So the trust protector steps in. Anna's parents have named this trust protector in their living trust in advance. A trust protector is a person, again, who has power over the trust, but who is not the trustee. So this might be a new concept for you. We have a whole webinar on what a trust protector is and isn't. And then the trust protector removes Anna as trustee and appoints a third party as trustee. So Anna reaches out to the lawyer reaches out to the trust protector, and then the trust protector removes Anna so that she no longer has access to her inheritance. And because she has no access, her creditors have no access to her assets. And again, outright distributions, I would put those in the old school category. And I will say this is not a slam on lawyers who write trusts with outright distributions. I will say that probably 95% of the estate plans I write have some form of protection for the beneficiaries. Very few don't. And, I would say this is an old school approach. But law is a practice. And what I mean by that, law is not a science. Law is a practice. And lawyers are practitioners. And a practice evolves. That's just the nature of a practice. It is not fixed. It's not static. And I think the new approach, the trend I'm seeing, is to protect the inheritances, as I said, that are getting bigger every year. And it's not just to avoid probate. So a lot of people said, oh, avoid probate. You got to avoid probate. Do a living trust. Okay, we get the property to the kids. Probate's avoided. Well, that's good. But the next question is, okay, well, once the kids get the property, is it protected? Because as I said, it used to be 50,000. Now it's 500,000 or $1 million or 10 million or whatever the number is. And I would say savvy lawyers, and this is not all lawyers. This is kind of, I would say, a rarer breed. So there are a lot of old school lawyers out there, but savvy lawyers know when and how to protect inheritances from threats, including divorce. And so sometimes it's not, this level of planning it's not appropriate, right? If the person's not married and they're never going to get married, you might still want some creditor protection, but not necessarily divorce protection if you know that that person is never going to get married. So is this a new thing? So is what I'm talking about here inheritance protection trust? I put this in my book, Savvy Estate Planning, which is available on Amazon. I called it the Inheritance Protection Trust. I came up with that name. It's nothing that's in any legal textbook. As I said, it's a descriptor for the benefits of a particular type of trust, but it's not like a legal doctrine. And again, it's more in the nature of a continuing trust, and maybe to dole it out as a spendthrift trust. Special needs trust is a legal term that you'll see in treatises and other materials. But is this a new thing? Not really. And again, it evolves over time. It's designed to protect inheritances that keep getting bigger. And again, savvy lawyers know when and how to protect inheritances from threats, including divorce, but there are other threats as well. And once we uncover this, once we kind of pull the onion back, I would say most clients want this incorporated into their living trust plans. They want this functionality because it makes sense. I mean, you took a lifetime to build it, maybe someone else's lifetime before you to build it, and then you added to it. It makes sense to protect it. So subscribe to our YouTube channel. I told you this is going to be a short one. How do you get started? Go to Cunningham Legal and you request a consult by completing our online request for an appointment. Just mention that you're seeking an estate planning consult and wish to discuss protecting a loved one's inheritance from divorce. And here's how you go to our website, and you can hit request an appointment. And that is the recommended way of getting to us. We are hitting a busy season with the Biden tax increases, but we're certainly here to serve our clients. So you can request an appointment. I will open it up for questions here. And then what I'm going to do is I'm going to put this back here so you see how to get started. So does anybody have any questions? Let me see here. We've got some questions coming in. Is this something that I can do after my parents have passed away? Well, I think by the question is this something that I can set up for my own inheritance? No, your parents have to set it up for you, or whoever's leaving the assets to you. They have to set it up for you. And we have a question. What about IRAs? I've heard that there's no creditor protection for IRAs. What can be done to protect IRAs? Well, we have the IRA Legacy Trust. That's a great question. We have the IRA Legacy Trust. And what the IRA Legacy Trust does is normally when you inherit an IRA, it is not protected from creditors whatsoever. And that was a Supreme Court decision, Clark v. Ramaker from 2014. And what the Supreme Court said is if you inherit an IRA, you inherit $1 million IRA from your parents, there's zero creditor protection, like none. Even with your own IRA, there's a modicum of creditor protection. 401ks, unlimited, okay? But if you inherit an IRA, there's no creditor protection. But if you use an IRA Legacy Trust, which is a purpose-built trust for an IRA, okay? If you use an IRA Legacy Trust, you can accomplish many of these same goals of protecting the inheritance, especially for a younger beneficiary. So, if you're leaving your IRAs to grandchildren and, they're 5, 6 years old, you can't leave an IRA to a 5-year-old. You've got to put it in some type of a wrapper. Otherwise, if you don't do that, then you have to go through a guardianship. If the beneficiary, the minor beneficiary, inherits more than $5,000. And, the other part of that is, even if they do that, once they hit 18, arguably they're just going to be able to take all the money out. And, a lot of people, they say, well, I don't want them to blow all the money. The other thing too about IRAs you have to remember is that's what we call a zero basis asset. If it's a non-Roth IRA, when you take money out of that IRA, you have to pay tax. Now, there are some ways of stretching that out now for, basically 10 years. And in the 10th year, you've got or the 10th tax year, which is the 11th calendar year, you need to take all the money out that remains in there. But there are a lot of hurdles you have to go through to get to that point, to be able to stretch those IRA payments out. And many people, I would say not enough lawyers, frankly, understand these rules, not enough CPAs understand these rules. So when you're leaving an IRA to a trust, you have to tread very carefully. You got to tread very lightly. Greg asks, an article on your website gives an example of a judgment against a person involved in a car accident, but only 1% at fault is found by the court to be 100% liable for the monetary judgment as the at-fault person has no assets. Does an inheritance protection trust address this and other similar creditor issues? Greg, absolutely. And that's an example. The medical expenses are if you're 1% liable, you're potentially liable for all of the medical expenses in a personal injury case. So yeah, but I will say, Greg, the incidence of people getting in a car accident and getting sued and not having enough insurance, I don't see that as much as I see divorce. Because that divorce is really, if there's a big gorilla in the room, so to speak, that is really is a red flag on, hey, this is a big problem, it's divorce. But absolutely lawsuits as well. One thing that people are also concerned about is if you own property in a rent-controlled area, Ellis Act properties, and you see these in Santa Monica, LA, San Francisco, Oakland, Berkeley, many times tenants have really robust rights, okay? And it is, I've seen clients and tenants get 250, 300, 350,000, okay? Clients have to pay it. And then I've also had tenants come in and they say, oh, they tried to evict me and I got a settlement of $350,000. So that is for a wrongful eviction. That is not covered by insurance, okay? So there are a lot of potential threats out there, creditor threats, divorce threats, taxes. We didn't even talk about taxes. If you have a large estate, many very wealthy people will do a dynasty trust, right? Remember the TV show Dynasty. It's the rich people show, right? So you put $10 million into a dynasty trust and it's never taxed again when people die. So that's kind of that's the thought there. Whether it's never taxed, what I mean by never taxed again is it's not taxed until the grandkids die. So if there are any other questions, I think this will be a short one. And one more question. Nina asks, if one's child marries with a prenup, does the prenup protect the child's trust inheritance from future ex-spouse if there's no marital commingling of child's trust funds? Yeah, Nina, that's a really good point. I'm assuming that there's absolutely no prenup, but a prenup can be very helpful in deciding, what structure to put in. Now, I will tell you that it's just not divorce we're protecting it from in Anna's case, and it's other threats, as Greg mentioned, getting in a car accident. But prenups, I'm ambivalent on prenups. I will just tell you, as a person who's been married almost 30 years, I'm not sure if I'd asked my wife when we first got married if she would have signed a prenup. I think it depends on the stage in life. A postnup is also a possibility, a postnuptial agreement, but again, that's it's really case specific. I think it's different if you have, two people who are in their 50s getting married. A lot of times you see people do prenups, people in their 30s, maybe people who have kids. But a prenup, absolutely, it's a good strategy and should be incorporated in divorce protection. And that brings us to the end of today. I wish you guys a great day, and go ahead and make sure you subscribe to our YouTube channel, and you can check out our website. Lots of good stuff. We just had a big update on the Biden tax plan. So check it out. And I look forward to seeing you soon.